So you have a trial date in a debt collection lawsuit. Can you take notes to court? Should you take notes to court? And if you do take notes to court, what does that mean? So my name is John Watts. I'm a consumer protection lawyer. And I want to tell you that at least where I practice in the state of Alabama, you certainly can take notes with you to a trial. Now, anything you take with you, so you walk up to the witness stand and you have some notes, the other side can certainly ask you about those. They can ask to see them. But there's no prohibition, unless just your particular judge doesn't want you to. There's no prohibition on taking notes. And we see this all the time in our personal injury cases. If we have a doctor testify, and usually they testify by deposition, but we can have a doctor come live to trial. And they'll bring their notes. They'll bring the medical records, or they'll bring notes that they've written down. Expert witnesses. We've had experts for train collisions and all sorts of cases. Well, they'll bring their notes. Hey, I went out and I measured how far it was from this sign to the railroad crossing, or I measured the decibel level of the horn, or whatever it is. And so they take their notes. So there's nothing wrong with you taking notes. Now, just understand, whatever you take with you, the judge and the other side, the collection lawyer, can look at. So what I would do, if it was me, is I would limit those notes to factual things. Okay, so you go through their paperwork, and I'll give you an example. Let's say that you are sued on a deficiency after a repossession. So you went down to a local dealer, and they gave you a retail installment sales contract, and then that went to Santander or City Auto or whatever, Capital One Auto, and then it went to AutoVest or Cascade Capital or Velocity, one of these debt buying companies. And they sue you. Well, one thing they have to show is that they notified you before the repossession that, hey, we have your vehicle and we're going to do this here's a specific day for a public auction and here's the location, or we're going to sell this at a private sale after such and such day. So, okay, seems pretty normal. All right. But what if, and I've seen this before, where let's say the sales date, they say, we're going to sell your vehicle on September the 15th. Okay. And the notice telling me they're going to sell my vehicle on September 15th is dated October 2nd. Well, unless I have the ability to time travel, that's a bit of a problem. And it's a real big problem for the company suing me. So if I was representing myself, I might make that note. I might have, here's the letter that came from the collection lawyer. And I might highlight up there, okay, October 2nd, and draw a line, and, here's when we're doing the sale. It's like, this is weird, okay, how they did it this way. And now this is sort of a separate video, but if you're bringing exhibits to court, in other words, evidence that you want to offer to the judge, I would have a clean copy for you. A clean copy for the judge, a clean copy for the collection lawyer, and then one for you, and that can have notes on it, okay? But I'm just talking about if you want to take notes so that when you're being questioned by the collection lawyer, you can remember things. Well, you certainly can highlight. And look, if they say, I want to see those notes, and the judge says, show them the notes, and they look at it, and they see highlighted, October 2nd and then September 15th, it's going to be kind of hard for them to get upset about that. So those would be the types of things. If we're talking about a typical debt buyer, so an LVNV, a Midland, a portfolio, that chain of title, and we've talked about that in other videos, they have to show that chain of title of ownership. And oftentimes, they'll be able to show it went from this company to this company and then this company. Well, what about that gap? Well, there's a break in there. Well, you sort of circle that, highlight that, maybe put in notes. It went from company A to B and then from C to D, but nothing from B to C. And so you could write that out. And again, if the collection lawyer sees that, if the judge sees it, who cares? So trial is not to be a game of memory. Okay, it's not to say, well, who has the best memory? Now, you need to know your stuff, and certainly as a lawyer, the way that I was taught is, you need to be able to question all the witnesses without any notes. You need to be able to do opening statement without any notes, closing argument without any notes. Now, I may have some notes. Usually I've got a notepad, and it may be sitting on the counsel table, but when I'm up questioning a witness, I don't have that with me, because this is the way I was taught. I want that witness to know in his mind and in his heart that I know the facts better than he does. But that's for me as a lawyer. If you're doing this on your own, again, you don't get extra points for, memorizing everything. What I would say is have whatever notes you need, whatever points you want to make, have them there, have things highlighted, have, notes written out, and that will help you. But just make sure that you're comfortable with the other side seeing those. In other words, you don't want to write a note on there, the judge is too dumb to understand them. You shouldn't have that thought anyway, but definitely don't write that down. Or don't say, I wonder if this idiot collection lawyer will realize. Well, don't put that down, okay? So just keep it very professional and make sure you're comfortable if the other side gets to see it. But there certainly is nothing wrong with having notes there at trial. So I hope that that's helpful to you. And if you are trying case on your own, good luck with that. And I hope you will be incredibly successful. And remember, if you are successful, look at your credit reports afterwards, because there may be a claim that you can make against that debt collector for suing you and for doing false credit reporting. Okay, thanks for watching this, and I'll catch you in the next one. Bye-bye.